There are situations where the kids get married and the parents would still wish to actually have their assets go to the kids only and try to neglect or ignore their spouses. What can you tell me about that particular scenario?
Well, it's a hot topic at the moment. If you just give your assets to your kids, those assets immediately become, on your death, they immediately become owned by your children. And they immediately, therefore, fall into what's called the matrimonial pool. So that money becomes part of the matrimonial pool of assets, and in the event that they subsequently divorce, or indeed even if they could even be separated. We've had a case recently where the kids actually were separated from the spouse, and immediately on the death, the estranged spouse ran up to the family court and changed all the documents, asking for half of the inheritance money, because that money had fallen into the matrimonial pool. Now, if you want to ensure that at the moment, the reason I say it's a controversial issue is that we have been trying to avoid that through the use of what we call a testamentary trust. That is a trust inside the will. So instead of giving our money to our children, we give it to a trust that sits inside the will, and the children are the beneficiaries of that trust. They don't own it. They don't own the money. They control it. But in theory, it falls outside the matrimonial pool. Now, I say in theory because the High Court has made a couple of really awful decisions recently which has undermined this a little bit. But at the moment, it's the only thing that we can offer you. If you put this money into a testamentary trust and you ensure that the spouse is not listed as a beneficiary of that trust, only your child and their children are listed as beneficiaries, then you maximise the chances that the spouse won't be able to get hold of the assets.
Okay, so it acts as a barrier, I guess.
Makes it a lot harder.
Yeah.
So Peter, can I just say that if it goes to your, say I have a son, and the son has a son, a grandchild, and they're separated, if the child is in the hands and under care of the mother, and my son's died or whatever, obviously she gets the money, doesn't she?
No, she doesn't get it, because the money is in the trust for the grandson. So your executor, your trustee, makes sure that the money is paid for his benefit. So while he's a minor, he will, and particularly if the mother is not doing the right thing, the executor would say, all right, I want to see bills. I want to see that you want to send him to a private school. You send me the invoice, and I'll pay it direct. That's exactly right. That's exactly right. And so you pay the money on behalf of the child. You probably give the mother something for the child's general upbringing, etc. But specifically, any large amounts of money are paid only to a third party on behalf of the child. And when the child hits, it depends on what the trust says. You probably put 25 in there as a good age at which they could have access to the capital as a mid-range. Some people prefer 30. Some people prefer 21. The vast majority of people say around 25. The money then becomes the grandson's, and that is then handed over to him.
Any other questions?
Can you take us through what's involved in setting up a testamentary trust, and the scenario I'm looking at is an adult son who's severely disabled?
Yes. The trust is set up in your will, so it's just part of your will, and there is no formality needed per se. It's just drafted into your will. Your executor, you can. The question is, who is going to be trustee going forward? You can choose. Your executor could do the job. You could choose someone else who you felt more comfortable with in carrying out that particular role. Or you could even get a professional, if there's enough money in it, unfortunately, but you could get a professional trustee to do it, somebody like Perpetual or Permanent or whatever. But they charge material fees, and so they won't do it unless there's a material fee involved in it. There may be even, and I'd need to talk to you about it, but there may even be potential for that within the disabled community, for example, the social working community, and some of the charities may provide services not dissimilar to that. But that's just the selection of the trustee, and to ensure that the money is effectively invested and effectively distributed on some sort of an agreed basis through the trust. But it's not, there's no court proceedings, there's no parchments or wax or anything silly like that. It's very just a straightforward drafting issue to be put inside the will.
Good, thank you.
But to set up that trust, is that not like setting up a trust company, or is it
No,
it's not a trust
no,
company?
it's not. You don't need a trust company. Your executor can look after it.
The will actually becomes the deed.
That's right. Your will
Most
becomes
banks
the
don't
trustee.
understand.
And so what does that cause problems there again, so they don't understand?
I know, it's just, you've got to go to the head office and get them to go open up the account, so that troubles.
Oh, to open up accounts.
Yeah.
Oh, okay.
It's becoming more understood.
Yeah, I would think so. I mean, this is not that cutting edge. It's been around a while.
So therefore the process is, as you said, reasonably
Relatively straightforward. Yeah, relatively straightforward. Look, testamentary trusts do add a level of complexity to the administration of an estate, and there have been a percentage of people don't want them because they're too complex.
and costly, I bet.
Well, yes, they add a level of complexity. But I mean, apart from anything else, the trust has to put a tax return in each year. So either you want the benefit. Either you think the benefit is worthwhile, or you don't. A lot of people say, no, it's too complicated. I'm going to give the money to my kid and let him sort it out. It's up to him. If he gets it into strife or he loses it or whatever, that's his problem. Whereas others say, no, I'm going to look after. I want him to make sure that it's, and they make the decision. So it's obviously, it depends on that you've got enough assets inside your estate to make it worthwhile, and that you've got a clear idea in your mind of what it is you're trying to protect.
Well, I'm very confused about
Peter.
this return.
Just in case I'm not right, I think there's one issue that I rubbed into with one recently that I was involved with. Am I correct that the beneficiaries have to accept the trust? It's not mandated upon them?
Well, that depends on the drafting in the will.
Oh, right.
Yeah,
It
so
can
the
be,
will.
this one here actually said that they could have just said, we don't want to do the trust,
Yes,
it's optional.
Yep. Yeah, so the will, I can often say, if they request it,
If they want to go ahead.
if they want to go ahead with it.
So that sometimes can, all your best laid plans.
Yeah,
Can be just bypassed because it's
yeah,
just too
which
hard.
is, I mean, but that's again an issue for mum and dad when they're drafting their will. Do they want to impose the
So
trust
you
on
can
the
make
kid?
it something that is.
Yeah, and you for example, and you can do even, you can have a bit both ways there. If you could, for example, if the kids are still relatively young, 18, say 19 something, and you think, oh, the last thing we want is for our kid to get a hold of a large amount of capital at the age of 19. So when we die, the trust is mandatory until they hit 25.
Okay.
Then they can decide if they want to keep the trust going or not. If they decide then that they don't want it, then they can wind it up. If they want to keep it going, then they can keep it going.
Can you make it older than 35?
Oh yeah, you can. Yeah, you make it any age you like.
Oh, I feel like that's the sensibility, yeah. But I mean, you've already thrown the tax return on the trust. Why, when it's not earning anything, or is
Well,
it
we'll be
earning?
earning. We'll be earning. You'll have a large amount of
So
capital. Your capital will be inside the trust. Let's say you die with, and after they sell your house, and your super comes in. Say your super came through the estate for the sake of argument. All of a sudden, you've got $800,000 in the trust. Now, at 7.5%, you're earning whatever it is, 12 grand a year.
So that's upon your death,
After your death.
after your death, not prior.
No,
to
it
that.
only
comes
That's
into
what I mean.
existence.
It only comes in after your death.
When you die, it comes in,
Comes into existence.
and even for argument's sake, and correct me if I'm wrong, a lot of people with the testamentary trust are trying to get that capital across to the child, so they can buy a house, so it's like an interest-free loan.
That's right.
And therefore, with the matrimony, you claw it back. So there's no tax returns involved then, because all you're doing is creating a loan. If they split up, then the trust stands up and says, "Hey, you owe me the money back," and trying to protect that bloodline of funds.
And of course, if the trustee distributes
Yeah.
all the income each year, then it pays no tax.
Tax and then trustees.
Yeah.
That's all very
And to put
complicated.
in the tax return and everything, it's the executor will have to worry about
Yes.
it. That's why it's very important to know.
All right, sorry. Yeah, sorry.
For the executor, do you have to ask permission, or do you want to make known to them, say, I'm going to?
Yeah, well, you do. I mean, in the sense that you probably need to make sure that they're happy to do it. You can't force them to do it. And if someone has appointed an executor, they can say no, I don't want to do that, and they can actually renounce. It's called renounce. They can renounce their role. They say no, I'm not doing that. I'm sorry. And someone then, another person has to volunteer to take up the role. So obviously you wouldn't want that to happen. You would want to only appoint someone who was happy to do it.
What happens if you appoint them and when the time comes for them to be the executor, they change their mind?
Then someone else will have to fill the role. Unfortunately, you won't be around to find that person, but somebody else in your family presumably will put their hand up and say, no, okay, well, we've heard this, then we volunteer, or maybe your solicitor or accountant or something will volunteer to do it in order to have the estate fixed up. But ordinarily most people, if you speak to them in advance and you say, will you be my executor, most people as long as they're happy to do it, and they say yes, once they say yes, they very rarely go up against it. They appreciate the fact that it will cause very substantial problem to the family, particularly at a time when the family is very fragile as a result of your passing anyway.
Going back to that previous topic of taxation, if the income from the trust is distributed to the beneficiary, then the beneficiary will be responsible to declare that one, but the trustee does have to pay the tax.
No, that's right. The trustee doesn't have to pay any tax if he distributes all the income.
Still has to lodge a return.
Yeah, and a particular person who's under the age of 18 is still treated like an adult for tax purposes with a testamentary trust. So in other words, the person who's 5 years old, a child's 5 years old, will still be treated like and still get the tax-free threshold, or no different to what an adult would actually be treated. And that's why a lot of testamentary trusts are actually put in place for those particular reasons.